I'm attorney Phillip Jusino, and this is Finding Common Ground here on Altice, channel 115. You can see this show every Saturday at 10 a.m. on channel 115 Altice. I am also back on the radio, FM radio, 103.9 FM, LI News Radio. That show is every Monday at 5 p.m. I call it Phil Jusino Drive at 5. Actually, it's 5:06 because people in the past have come on and said, I turned it on at 5 o'clock, or it used to be 8 o'clock, and I didn't hear you. News and weather and commercials. So about 5:06, you're going to come on. I'll be on. Got a great show planned for today. We have Marty Tankleff in the studio. Marty was on my show about 4 or 5 years ago on FM radio. Then he was on a show after that time. I'm not going to dwell too much in Marty's past. Contextually, I'm going to talk about it a little bit, but we want to get beyond that because that period of time did not define Marty. Marty's parents were killed in June of 1988 in Belterre, which is right near Port Jeff, New York, here on Long Island. He was convicted in September of 1990, if I'm not correct. Am I mistaken? I am mistaken. When was that conviction?
So the murders actually took place September 7th, 1988.
That's right. The day, first day of school?
First day of high school,
First day of high school,
so
that's
September
correct.
7, 1988.
That's right.
My mother was deceased. My father clung to life for a few weeks. When he passed, I was charged with his murder. And I was convicted of both homicides on June 28th, 1990.
1990.
And then I was sentenced to 50 years to life in October.
Right. In fact, I was in the DA's office at that time, the time of the trial. I had nothing to do with the case, but I remember it because on Long Island, obviously, it was a very, very big case. And you served 17 years in jail.
17 and a half years, 6,338 days.
You remembered it.
I do.
Right. And then ultimately, the New York Supreme Court Appellate Division unanimously exonerated you. They vacated your sentence.
They vacated the conviction, remanded it back down to Suffolk County Criminal Court. At that time, DA Spoda had announced that he was going to move to dismiss the indictments. We found out afterwards that there appeared to have been some backdoor issues, and Governor Spitzer had appointed a special prosecutor who was Andrew Cuomo. And several months later, after they had uncovered more exculpatory evidence, they moved to dismiss the indictments against me. Got
it. And I remember doing my research, and there was a lot of information in the 440 motion that was made on your behalf way back when, and that's a motion to set aside the verdict. And I remember polygraph information was used, which is not admissible in a trial, but it was admissible in the 440. So I had heard a lot about the case. There was a lot in the media, but that 440 motion for me convinced me, because prior to that, you hear a whole bunch of different things. You know, there are people up to this day that say you're guilty.
So it's very interesting. Bruce Marquette, who was one of the lawyers that represented me in the post-conviction proceedings,
I know Bruce.
Recently sent me a message that he was at the Nassau County Jail. He ran into a court officer who remembers me showing up the first day when I was brought down for the 440 hearings. And that court officer said, after I spent an hour talking to Marty, my opinion of him completely changed, and I went home and said, there's an innocent man in jail.
Wow.
And what I also tell people is that, you know, unless you know the true facts of the case, not what's just in the papers, and I talk about the newspapers, if you actually look at the filings, the legal
You mean they get it
documents,
wrong, the newspapers?
They get it wrong. Quite often they do get it wrong. Quite often they don't have access to everything. We developed a body of evidence through civil rights proceedings that has never been public before, which probably was one of the reasons why Suffolk County was inclined to settle the case, because they knew and they saw the body of evidence we had developed, which had never been made public before.
And that happened, you talk about also Brady violations, I'm sure.
There's Brady violations, there's witnesses that were afraid to come forward because of Jerry Stuerman, Todd Stuerman, Peter Ken, and Joseph Creedon, who were all involved in the murders. And as some of those men passed away, more witnesses have come forward because the fear that those men instill in them have evaporated.
Wow. You know, like I said, I remember that period of time. I remember also the exoneration. I still remember there were many pictures that came out in the press. You leaning or sitting on a car when the detectives were questioning you. That was, I think, the morning that they found your parents dead.
Yeah, that was Detective James McCready had moved his car away from my house. And we later learned it was a tactic so anybody who showed up at the house wouldn't see me right away. And we know that to be true is because when Mike Fox, who was my uncle, my godfather, and the family attorney showed up, he never saw that I was there that day.
So they can continue to question you.
Yes.
I didn't know that.
Yes.
Now, and also there's the famous picture of you crying when they read the verdict. And you were at that time
19.
19, because it was 2 years later, the trial. What was going through your mind at that moment?
Well, it was 8 days of deliberations. So you have this faith in the system, or at least I did as a kid. I mean, you grew up in, 1980s in Long Island, 1990. You trusted the police.
You grew up in an excellent neighborhood?
Excellent neighborhood. The rumor was the longer the deliberations go,
Right.
the more favorable it would be.
Generally, that's true.
Generally, it's true. Back then, in New York State, you were able to charge depraved indifference and intentional murder. Obviously, now you can't because of the New York State Court of Appeals decisions, but back then, I had both charges against me. So the first announced verdict was not guilty.
Right.
So with that, everybody kind of had the sense of release, and then they said guilty. And I don't really remember much after that. But the picture you see is me crumbling when the guilty verdict came down, because it was just, I guess you could say, just complete shock and disbelief. I mean, I remember the next thing after that was I was over in the Suffolk County Jail, standing in front of the property room, the court officer over there with the sheriff.
This is after the verdict?
After the verdict. I don't remember, guilty, I don't remember anything after that, other than being at the court officer's desk area by the property room, and them saying to me, "What are you doing here?" And I said to him, I said, "Why else would I be here?" And they all looked at me and said, "There's no way they found you guilty." And I go, "Why else would I be here?" Yeah.
Wow.
And as years passed, a lot of court officers, police officers, anybody who kind of was independent, I would get messages from. "We believed you, Marty, but because of our employment or because of our status out here, we couldn't publicly say that."
It's interesting you say that, because I spoke to a number of court officers when the hearings were going on. This is years later. And usually get a pretty good sense, because they're sitting in that courtroom. They're listening. And they tend to be law and order, right? So you think a lot of times, yeah, that guy's guilty of sin. They said to me, because I was there for other cases, but they said to me, "I think this guy's innocent. I mean, we don't think he did it." And for them to say that, and I remember telling other people that, and I said, that speaks volumes.
There was a court officer who was actually retired during my 440 proceedings. And at one point, he asked the judge that if he could stop the proceedings, because he also worked my trial. And he said, he goes, "I find it amazing that almost 20 years ago, I was a court officer in the trial, and here I am almost 20 years later retiring, and Marty Tankleff is back in this courthouse. And I want to thank the family and everyone for everything." And it's interesting because even since then, I see former court officers all the time now. I've been invited out to lunch by them. What I always tell people, I said, they've seen every type of proceeding. They've seen every type of evidence. I mean, they've seen probably more than most criminal defense lawyers have. And they are probably some of the best judges of guilt and innocence.
Because they're in the courtroom from start to finish often on a trial. They see all the witnesses, they hear the rulings. We were talking a little bit about the shock you had when you were found guilty. I've spoken to many people that were wrongfully, Jeffrey Deskovic, you know Jeffrey, I'm sure, and other people. And they say something very similar, because they know they didn't do it. Other people might not know. The media, even their own attorney might not know 100%. And then all of a sudden, they find themselves being convicted of something they didn't do. And it's got to be, I can't even imagine. It must be so nightmarish. And at a young age, Jeffrey was about that age.
About the same age as
About the
me.
same age.
Yeah,
So
we were
it's
both
not like
high
you have a
school.
40-year-old guy with life experiences. You're like, what do I do?
Essentially, what I tell people is this: you're thrown into being a man almost instantaneously. And I still revert back to what a family member said to me once. He said, "It's time to be smart, not emotional." Because when you're in that situation where your life is on the line and you have to fight for your freedom, emotions can really distract you. And I remember having to keep that message throughout my incarceration, because I was also told by somebody who was a former cop who was in prison, who said to me, he said, listen, Marty, he goes, it is the easiest thing to convict an innocent man, and one of the hardest things to do is exonerate
Exonerate him, sure.
And he said the way that exoneration is going to take place is you being your best advocate.
Right. And it's amazing to me because guys that I've spoken to, like you, like Jeffrey, there's another guy from Texas, who Geraldo Rivera went to interview. I know you might have heard of that story. He went to interview someone, and while he was there, he said, anybody else here didn't do it? And they pointed, because the people in the jail believed this particular man, I think his name was Edwards or something, and Geraldo spoke to him, and then Geraldo actually interviewed the DA, the former DA, who basically confessed. And that guy was ultimately, I think, prosecuted, and this guy was released. But what I'm trying to say is the length of time. Look how long it took you. Look how long it took Jeffrey Deskovic. When you hear about these exonerations, it's not like, wow, that guy was in jail for 6 months. It's 15 years, 16 years, 20 years. Why? Why is that?
Why is that? I'll give you a perfect example. I'm an adjunct professor at Georgetown University where I co-teach a class with my childhood friend Mark Howard that we call Making Exoneree. In our first semester, we utilize undergraduate students to reinvestigate cases, try to come up with new evidence, and they create short documentaries. In our first semester, we had one group of students who took on the Valentino Dixon case, an African-American man convicted of murder and weapons charges out of the Buffalo area. The two of our students went up to interview the former prosecutor on the case. The former prosecutor disclosed something that had been withheld for 27 years. He said on the day Valentino was arrested, they did gunshot residue tests and they came back negative. That had never been disclosed.
Oh my God.
Now, to make matters worse, a few days after the shooting, Lamar Scott, who eventually pled guilty the day Valentino was exonerated. So 3 days after the murder, he gets on camera and says, I did the murder, I lost control of the gun. Years later, when Lamar got arrested for another crime, he said, had you arrested me for that murder back then, which Valentino Dixon is in prison for, I wouldn't have been able to commit this crime. Throughout the 27 years, Lamar Scott admitted his involvement countless times. But Valentino Dixon spent 27 years in prison, and if it wasn't for our Georgetown students and uncovering that evidence and some other evidence that they did, Valentino Dixon would probably still be in prison today.
What's the solution? Like, how can we speed up the process for these guys so they don't spend 16 and so years in jail? How do you speed it? Because I know the prosecutor and the police, we got the guy. Our job is done, right? In their minds. Right. They got the guy. You were guilty. You were the guy that committed the murder. Why are they looking for anybody else?
So there's two issues there. When I do sometimes public speaking events and I ask a group of, let's say, 50 or 100 people, I said, if there's a murder in your neighborhood on a Friday, and all of a sudden Monday, police say they've arrested somebody for that murder, how many people are satisfied with that case?
Overwhelming majority.
Overwhelming majority. Then I say, well, how many of you in this room know the right person was arrested? Did you ever hear them say the right person was arrested? And all of a sudden they said, well, we never thought of it that way. They said, we trust law enforcement. Mm-hmm. They said somebody was arrested, that means the right person. I said, that's the problem. We need to have more accountability. I said, when we start demanding that law enforcement do more investigations, take their time a little bit. Right. Because sometimes it's that rush to judgment. Right. I mean, in my case, I was arrested within 24 hours, and all of a sudden, within days, my father's business partner faked his death, changed his appearance.
That was a bizarre case.
Fled the jurisdiction, and law enforcement never considered him a suspect. Even though there was a financial benefit to the murders.
He had a motive.
And his motive, his conduct. You know, when I tell elementary school kids, junior high school kids, everything that Jerry Sturman did, they go, how was he not prime suspect
in the law, we call
one?
it consciousness of guilt in many respects.
Right.
He acted like a guilty guy.
I mean, if you think about this, cleaning out a joint bank account, faking your death, you know, changing your appearance, having 5 aliases, not one alias, 5 aliases, fleeing the jurisdiction, going from New York to New Jersey to California.
Didn't he end up in Florida?
No, California.
Oh, California?
In California, hiding out in a psychiatric retreat after he had his hair changed at a hair club of America out there. So the hair that was in his head, you know, wasn't the same hair that he would have had a week before. He had a code word that he allegedly calls his wife and says pistachio, and law enforcement claimed back in 1988 that they were able to trace the call by saying one word, pistachio. And everyone I've spoken to said, how is he not suspect number one? And the tragedy of it is, over the years, every piece of new evidence went back to him.
Why do you think, look, I got to believe, as a former prosecutor and also, let's say, a police officer, they want to get the right guy. And when they do, maybe they're careless or, God forbid, worse, hold back information, they think they're doing a public service because we want to make sure we keep that bad Marty Tankleff off the streets. How do we change that culture?
Culture is really education and training. I mean, it's education and training, and it's also having those in law enforcement, those in prosecutors, meet exonerees and hear their stories and to understand
good point.
What went wrong along the way or what could be different. I also think zealous advocacy is so critical.
Oh, absolutely.
I could tell you a very quick story. Bruce Barquette represented Nicholas Morris for 2 years. Throughout the 2 years, because I was working in Bruce's office at the time, throughout those 2 years, Bruce kept telling the DA, listen, my client's innocent, my client's innocent. The DA wouldn't listen.
He was in jail at the time, I'm sure.
Nick was in jail at the time. A horrible crime. It was a drive-by shooting of a 4-year-old boy, I think on Easter Sunday, while they're going to church. They make opening statements at trial. The judge says to Bruce, after opening statement, have you told everything you just said here to the line assistant? Because I've been trying for 2 years.
Wow.
The judge said, would you consent to a mistrial if I get you a meeting with the Bronx DA?
Oh my God.
And they appoint somebody new. They consented. 45 days later, Nicholas Morris was released, murder indictment dismissed. 6 years later, the actual perpetrator of that crime was arrested.
Now, if you put that in a movie script, people would be like, that's not going to happen in the real world.
I never knew the impact that story had till Robert Johnson spoke at Toro Law School and told that exact story without mentioning any of the names. And afterwards, I came up to him, I said, that's a Nicholas Morris case. He said, how do you know? I said, I work with Bruce Barquette. He goes, you should follow that lead, and every lawyer should understand the zealous advocacy continues every single day you represent somebody, because you never know when something just like that, where the judge just said, something's wrong here. And I think that's a critical issue too, is that sometimes judges should take that inherent judicial authority.
But they don't.
They don't. And that's
maybe because
issue.
they feel it's not their job. You know what I'm saying? They'll be like, that's for the prosecutor to do.
Preventing a miscarriage of justice or a wrongful conviction should be everybody's job.
I agree.
Especially a judge's, because the judges can stop the proceedings. There's so much they have. I mean, there's areas of the judiciary law that some judges aren't even aware of that they can take advantage of to actually help them in that situation.
Right. Now, I know you've spoken at the New York Police Department Training Academy.
Yes.
How did you get invited to do that, and what kind of experience was that?
So I got invited through, there was a captain, I think his name was Sosnick, reached out to the Innocence Project, and they said, do you have an exoneree that would be comfortable coming to the NYPD and speaking about interrogations and false confessions?
Right.
And they reached out to me, and I said yes. And I'll say it really was one of the most memorable experience I ever had. I mean, for me, like walking into a police training environment, I mean... Surreal, not something you want to do. And being in a room full of, senior police officials, and some of them from outside of New York too. There was a captain of a police department that instituted electronic recording of all interviews and interrogations, and he spoke on the issue how when the policy was being discussed, there was this initial reluctance from law enforcement. And after they instituted the policy, there was like a 99.5 favorable rating because the videos protected everyone.
Sure.
They cut back on, extensive proceedings. They eliminated false allegations. So all of a sudden law enforcement said, these videos actually help us. They protect us. And the videos actually protect everyone involved. But it really was a great experience. I would do it again.
You well received?
Well received. I actually was given a certificate from the police department for my participation. And I would do it again because I think education and training is what is so critical in an effort to prevent wrongful convictions. Because quite often we focus on addressing the wrongful conviction. I think we need to focus more on the front end in preventing
Preventing it, yeah.
because
An ounce of prevention,
yeah,
Exactly.
there's an ounce of prevention. For me, I remember at one point we were speaking somewhere, and a PBA representative had said, "We don't want videos in the interrogation room because we don't want suspects to know what we're doing." My response was, number one, if you're not doing anything illegal, don't be afraid. And number two, is the value or the expense of the videotaping recording more valuable than 17 and a half years of my life?
Right.
Because I've said if that interrogation took place on September 7th, I never would have been found guilty. I never would have been charged with a crime.
Right. And it gives the jury something to really process and consider, because you don't. You're relying on the honesty of the officer, and you don't know the surrounding circumstances of that. Like even, let's say when they were questioning you on the car, are you saying that particular encounter
Everything.
should have been videotaped?
Everything, because every expert I've ever spoken to, and most exonerees I've spoken to, who have said if the recording started from the first question, I never would have been found guilty. And most experts will say the same thing. If the detectives who were by the car wearing a body cam, that's recorded. If you're brought to police headquarters, your movement is all recorded. The interrogation room is recorded.
Sure.
And most have said, guess what? You don't even have to tell the suspect they're being recorded. And it protects everyone.
Not in this state.
Okay, not in this state.
Right.
And you know what? It protects everyone. It really does, because when a suspect is being interrogated, we don't really know how long that interrogation takes place. A lot of times in court, you may see the confession, which could be 15 minutes of a 10-hour
That's a tail end.
interrogation.
Right.
Well, what happened during those 10 hours? Are we supposed to rely on law enforcement to come into court based on all the issues we know about, or would we rather simply rely on videotape? Because we know videotape pretty much shows what really happened.
Right. And I think it elevates the game. It would almost be like if there were cameras in the courtroom, and let's say the attorneys would even be better than they probably normally are, because you want to make sure you don't look like a fool.
Right.
You do everything. Not that attorneys don't prepare for trial. I'm not saying that, but it almost ups everybody's game. If you know that what you say is being recorded and you're talking to a suspect, you're going to be more by the book, I would think.
I would tend to agree with you. How many cases have we seen in New York over the past few years where officers write up DD-5s or post-arrest reports, and all of a sudden a video comes out, and the video doesn't even come close to the written report? If the officers know they are being recorded, see how much more accurate their reports are.
That's what I'm saying.
It really
Ups
is
the game.
It really does. And I think, for me, I've seen too many cases. I saw a case in Nassau County. African-American man says, 2 detectives bum rushed me in my car, assaulted me, and then I got arrested. And everybody heard this story and they kind of said, yeah, right, really? And all of a sudden, the cops didn't know this, but there was a videotape of the side street. The videotape came out, and that's essentially what it showed. It showed these 2 officers going into the suspect's car. And I think we were at a point, I think we are now different, but 10, 15 years ago, if a suspect came in or a client came in and said to you, listen, this is what happened, you would probably have some reluctance to believe them, right? But now, I think with the advent of the technology that everyone has, you would tend to say, you know what, he's probably telling the truth, because guess what, a video is going to surface sooner or later.
And it does. And think about it. Almost every police counter in public is videotaped in some way. Everybody walks around with a camcorder, in a sense, on your phone.
I was recently in an Uber car, and we were talking, and he's got a little camera right by his rearview mirror. And he said to me, he said, you know how I protect myself? He said, when I get pulled over, I said, what? He goes, I turn the camera towards the window. He goes, and ever since I've gotten the camera, every time I've gotten pulled over, there's a different position the officer takes.
And the cop knows about it.
Cop knows about it. He can visually see he's being recorded. And he said, he goes, you see this difference automatically.
See, that's why, and I've had shows, in fact, with police officers, politicians, body cameras. Look, there are pros and cons in everything you do, but it protects officers as well. I saw one where a woman alleged that the officer groped her or something like that, and you saw the body cam, and it didn't happen. If that didn't happen, that officer would have been in a lot more trouble. He would have had to maybe the case would have gone to the next level. Who knows? But a body cam, and it's also great for training.
It's great for training.
We did a show the other day, and we dissected these two officers by the book, and how this punk, I'll call him, in a car ended up shooting the two officers who got one of the guns. And it showed that it was Tulsa.
I think I saw that. Yeah,
Tulsa.
I saw the video recently.
Right.
This is the one where the kid was like almost crying and
he's like,
struggling to get out.
I just bought the car. And,
Yeah.
and the officers are like, now look, granted, they know they're being taped, so they're going to be, again, by the book. And it was tragic because they did everything that they were trained to do. In fact, maybe years ago, it wouldn't even got to that point. They would have been like, all right, we're 3 minutes into this, get the hell out of the car, we're going to wrap you in the head.
Yeah.
And the sergeant went around, and they tased him. Again, didn't phase him to that extent. It might have been pepper spray or some substance.
Pepper spray. It
was
was pepper
spray.
or, yeah.
Right, and they sprayed him. And the guy still got up. I saw another video, you probably saw this too, where this big man, it was like a tent, it must have been some kind of function, and a big cop came in and tased him, because the guy was, the fellow was wielding a knife. Tased him. He goes back, the suspect goes back, the cop then figures, now's my chance. Goes up there, the guy got up and slashed the heck out of the cop. Didn't kill the cop, but slashed, I saw pictures, really did a number on him. That's a perfect example where someone has a knife. To me, that's lethal force. So maybe a taser or pepper spray is not going to save your life.
There was a family friend who was a former Suffolk County officer, and he said, we've been trained that there are drugs out there that suspects take that make them unfazed, where they could be high on PCP. You could shoot a suspect, and they just look at you and laugh, like it doesn't even faze them. But in addition to the body cams, I think dash cams are so important.
Yes.
And
especially in a DWI stop, and you see it.
I mean, there was an episode of Law and Order where a patrolman pulled somebody over for a DWI. It was a woman, and the woman said the cop groped her and everything. She didn't know it was entirely videotaped, and there was audio. And all of a sudden, when the video and the audio came out, it showed what the cop said. And listen, we know cops have difficult jobs. We understand that.
Absolutely.
Okay, it's a challenging job. We see that every day. I've been asked as an attorney now, how can you represent somebody who's guilty? And I tell them very simply, when you represent the guilty, you protect the rights of the innocent as well. And most people don't understand that until I start explaining to them about search warrants or illegal search and seizures. And they say, oh, we get it now. Because I said, if you defend somebody who's guilty differently than you defend somebody who's innocent, you're not protecting your rights. And the protection of individuals' rights is so important in this day and age, because we see people getting victimized in every walk of life.
Right.
And earlier we spoke about false confessions. We focus on false confessions in, let's say, the criminal justice system. What about in the work field? I worked with a false confession expert who was brought in by a corporate compliance officer of one of these big chains, where a suspect was accused of stealing the petty cash. And they got the suspect, shouldn't even call him a suspect, they got the employee to confess that if he would just give the money back, admit that he stole the money, give the money back, they wouldn't report it to the police, and he would just lose his job. Lo and behold, he confessed. They did report it to the police, okay? And they found out later it wasn't him.
Wow.
So, I mean, there's a lot of issues. Like earlier you spoke about polygraphs. Most people, like you said, don't realize the power of polygraphs. New York State, you're not allowed to use a polygraph at trial. However, they are admissible in criminal proceedings in New York as pretrial proceedings, post-conviction proceedings, family court proceedings, and immigration proceedings. So I think, we're talking about zealous advocacy. I think criminal defense lawyers really need to kind of expand what they're doing and utilizing more of the tools that are out there when they take on certain cases.
Right. I once had a case, maybe 2-3 years ago, where a guy was charged with rape. I got a phone call from the wife, and it turns out it was a consensual situation in a dentist's office. There was a camera. We got the camera. We showed it to the DA. He was arrested on a Saturday morning. I remember I had to go over, Friday night. Saturday morning I had to go to court for the D11 over in CI. And I knew about the video, but I didn't have it yet. So I said, as an officer of the court, I'm told there's a video, but I got it to the DA that Monday. They ultimately dismissed the case. They did the right, well, it was clear.
Clear.
And I remember speaking to that ADA, I won't give the name, and she said, Phil, I was convinced that your guy was guilty. The complaining witness was so believable. And my poor guy, he didn't do it, right? He put himself in a tough spot by doing what he did,
Right.
but he didn't commit a crime. And it was, I don't want to use it, maybe funny is not a good word, but the woman walks out of the room that they were in. So you couldn't see but what convinced the DA was she showed up, she touched him in a certain way. They went into the room. She was a nurse from next door. Mm-hmm. She comes out and she looks to the right. Now, from what I understand, I saw a picture. The camera didn't look like a camera. It looked more like a mirror. Mm-hmm. So she looked up, like, anything, and she was convinced there was no camera.
Right.
Because then she reported. And to make matters worse, so the case gets dismissed. I get a phone call from a civil attorney in the city who was going to represent her in a lawsuit against my client. And he calls up very cocky. He says, yes, I said, the case was dismissed. He says, yes, it shouldn't have been. And I said, what's your email address? So he told me, I said, I'm going to email you a video. Please take a look at it. He calls me up. He says, I'm not bringing this case. And I had another one years ago, Napatandy's in Smithtown, where a woman, won't get into too much of the details, but she alleged that she was raped in the bathroom of Napatandy's. Turned out to be a lie. The guy did 3 days in jail. Thank God that was it. There were no videos at the time, but the police went the extra mile because they said, wait a minute, in the bathroom, nobody heard anything? They arrested the guy, but 3 days later he was released. No video, but again, you're using common sense.
But I think one of the key issues you spoke about in each one of these is zealous advocacy.
Right.
You fought for your client, and I think you get a gut feeling. I mean, I've been asked over the years, how do you know when someone is innocent? I kind of say, you get that gut feeling. As somebody who's been wrongfully convicted, who's been through the system, I have what I call the Marty litmus test. When I ask people, I said, are you willing to do a DNA test? Are you willing to do a polygraph test?
I was going to say,
do
exactly.
Anything else?
And you watch their face.
And you watch their face and you see their answers.
Right.
And it's interesting, because in the Valentino-Dixon case, that's exactly what we did. And he actually challenged the DA. He said, I'm consenting to take a polygraph test. I want you to see how many of the other people will take one. Mm-hmm. He took one, passed it. And the impact it had on the assistant DAs who were reinvestigating the case was important, because when he was exonerated, he was up in Buffalo, and I spoke to them. And they all said for them it was the icing on the cake. It confirmed everything they did. Mm-hmm. So he knew, and we all knew, that his decision to take the polygraph was so critical and so vital. And that's why I say, when you're truly innocent, consider taking a polygraph. It's a tool.
I agree.
It's a tool. It is not a make or break. Some people think you have to accept it 100% for the truth of it. But if you ask most people in law enforcement, I don't know if Suffolk County still has this policy, but there was a point where to become an officer in Suffolk County, you got to pass the polygraph. CIA, FBI, all these law enforcement divisions have polygraph divisions.
It's a great tool.
It's a tool. And when the tool is utilized correctly, I think it has an advantage. It is with using forensic linguistics. A lot of defense lawyers don't know about that. It is the incorporation of language and law, where the Unabomber, that case was solved using forensic linguistics. Mm-hmm. There's a professor at Hofstra, Robert Leonard. There's a former FBI agent, Jim Fitzgerald, who do these lectures. Mm-hmm. And it's just amazing where forensic linguistics you can actually utilize in divorce proceedings, plea negotiations, false confessions. And false confessions is one very quick example. Professor Leonard was asked to review an alleged false confession of an African-American suspect who was interrogated by 2 white detectives. He read the confession, he spoke to the defendant,
I see it coming.
And he goes, that's not the defendant's words. No. He said, what do you mean? He said, it's 2 white men trying to speak black vernacular, putting it into writing, and making a confession. And guess what? He was right.
He was right. Last night I was watching Forensic Files, and they had this linguistic expert, and he was able to look at writings of a serial killer and writings of another man that they thought was a serial killer. And it turned out the way they speak or the way they write things down, how they use words and phrases, it was compelling.
That may have been Robert Leonard. I don't know if it was the devil strip mentioned in that episode?
I don't know, but they were able to use this. It was a white fella, right? Yeah. Maybe it was, but the expert, and it's funny because sometimes they have these experts in things you didn't even know, like sneaker wear. They caught one guy because in the bottom, the bottom of your sneaker is like a footprint, in a sense, because you step on things. The bottom of your sneaker is not going to be anywhere near what the bottom of my sneaker looks like. The wear is different. We step on things. It's amazing the tools they didn't have. I think about like 100 years ago. They didn't have any of these things. And yet they had trials.
when I was at undergrad, I actually took Professor Leonard's classes because I find him amazing. And I also think it's actually kind of cool that he was one of the founding members of Sha Na Na.
That's it.
That's it.
It was.
So,
they mentioned him. They showed a picture of Sha Na Na. That was him.
That's him.
Okay.
So now what's interesting about him is that he was going to Columbia at that time, and at Columbia you had to take a foreign language. But the band traveled on Fridays and Mondays, so he ended up taking Swahili. So he is a professor of Swahili who has actually lived in Africa and is one of the country's leading experts on forensic linguistics.
That's amazing.
But we learned about a situation where there was a case out west where I think there was a note where it mentioned the devil strip.
Okay.
And all of a sudden, by consulting certain forensic linguistics, they knew in this one region out west, the devil strip was the piece of grass between the road and the sidewalk. And they asked law enforcement, do you have a suspect that lives in this community?
Because anywhere else we would know what the heck you're talking about.
Didn't know, and guess what? He was right. There was a suspect in that community,
right.
And they used forensic linguistics.
And a lot of times, that doesn't necessarily seal the deal, but it certainly leads you to the right person, or it's very powerful information.
They worked on a case, I think in Louisiana, where there were certain postings, and there were troublesome postings. They analyzed the postings, and they said, okay, it's a smart person, somebody who's educated in the law. Then they started researching actual legal filings. And they found exact similar passages or language, and they were able to identify who the person was, and I think it was a former U.S. attorney who was making these postings by studying language and law and the intersection of it.
That's amazing.
And, when I took his course, I never even thought about analyzing confessions or contracts where, one paragraph, each side could interpret what that paragraph really means. And we learned about a case where the placement of a comma meant $2 more either for like one corporation versus another corporation. And it was just amazing where the placement of a comma in a contract could mean that much of a difference.
And like with ransom notes and things like that can come in. Even with the John Benet Ramsey, there was a whole body of thought as to who did it, why the dollar amount of the ransom request and who talks like this and that can sadly they didn't make an arrest in that case, but it was just amazing how these experts out there. And it's funny you mentioned about Sha Na Na because they showed a picture. So is Bowser like a DNA expert or something? No, but when you said that, right away, because they had the picture of Sha Na Na and he's like the guy to the left, and it's amazing.
It's amazing because what's actually kind of cool is that...
You would never think a guy from Sha Na Na would...
When I was in undergrad and I took his class, I knew who he was. And if you told the class you mentioned Sha Na Na, nobody would know who it was. But he showed a video one day, and the video says, Robert Leonard, former rock band member of Sha Na Na, opened up for Jimi Hendrix at Woodstock. And you saw the whole class go, holy... one of those moments that like the class was like, wait, you opened for Jimi Hendrix? Like you were a
Woodstock?
rock star? Yeah, Woodstock. Like, that they knew.
That they knew.
And they were looking at this guy going, they just couldn't fathom like this kind of like down-to-earth, intelligent professor was a rock star at one point.
That's amazing. It's funny, you talk about polygraphs. I used a polygraph where the complaining witness, they actually had the complaining witness take one. My guy took one. It was a student at Suffolk Community College that was accused of a rape. And the parents of the complaining witness, one lived in Belterre, as a matter of fact, and my guy passed the polygraph. The complaining witness failed. It turned out later that the person wasn't where she was supposed to be. So she lied, and then when something happened, she only had my guy's name, and she had been with my guy that night, but there wasn't a rape. Right. The other thing you got to be careful of, and you might have heard stories like this, where even if you don't necessarily pass the polygraph, it doesn't mean you're guilty, because there was one guy who was with this woman and it was kind of rough sex. And he ripped her blouse. And when he was asked her, because there was buttons missing, they asked about that, he lied. He didn't rape the person, but he was there with her and he did rip the blouse, but he lied about it. He said, no, I didn't rip the blouse. So it came up as a lie or deception.
It did. So that's why through our Georgetown class, we've had the opportunity to work with one polygraph expert in particular. And he said that quite often for criminal cases, some of the best types of polygraphs are single issue or single question polygraphs. For example, if somebody was accused of shooting somebody in a bar on a particular night, the most important question is, did you shoot the person?
Right, that's
Not were you in the bar, were you planning on going to the bar? And sometimes you want to avoid those questions because you want to address the most important issue. But he gave a lecture to our class. And he said, there are times when I do polygraphs, because I do a lot of pre-polygraph examinations, where we go over questions and we do, issues. He said, I can almost tell if somebody's going to pass or fail. Really? Just how deceptive they could be in the initial questioning. But like we said, they're not 100%, but they're a tool. And I think they're a vital tool that...
along with other things.
There's so many other things. There's DNA testing. We're starting to learn that some of the forensic sciences, though, aren't as accurate because there was the case where the fingerprint analysis showed a gentleman, I think in Arizona, was linked to a bombing, and I think in Spain, and it was a wrong fingerprint. We learned over the years that serology lab work can be problematic if the lab technician is fabricating evidence.
Oh, of course.
Peter Zane down in Virginia was involved in fabricating evidence in hundreds of cases. Nassau County a few years ago, I remember that, with the DWIs, where there were, I think thousands of cases because they weren't calibrating the machines. But if you think about it, what does it all revert back to for us? Is zealous advocacy for your client, really kind of following every lead, understanding every forensic science. I tell people, listen, if it's an area that's beyond your expertise,
get an expert.
Get an expert. Consult with somebody. Bring somebody in that can actually simplify it. Because especially if you have to present to a jury, there's a lawyer that I used to work with that talks about how the courtroom is your theater, your jury is your audience, and your witnesses are your characters. And sometimes you want to make trials a little bit entertaining and simple, because when you get too complex, you can lose jurors.
Right. Yeah. I believe New Mexico is still the only state, unless they added more to it, but New Mexico allows polygraphs at the trial stage. That I know for a fact. It was Breaking Bad. Now, but I did my research one time, and that was at that time that was the only state that allowed it.
I think
at the trial.
Last time I had spoken to the polygraph expert, he goes, "There's a few more states that allow the admission of polygraph evidence at trial if the prosecutor and the defense consent before the examination."
Oh, before the examination.
Before the examination.
Of course. Right. It was funny. I was wanted to bring up. I was thinking about it before. Remember I think her name was Leslie Abrams. She was in the Menendez. Remember the Menendez?
Yes.
Okay.
She's a professor at UCLA.
Oh, could be the blonde-headed lady, and she became very famous. And I remember somebody questioning her about what is it like, and you mentioned this, to represent, someone who's guilty. And she said, what's really scary, and I'm paraphrasing, is representing someone who's not guilty. Because if you got a guilty person, like you said, you have your job to do, you protect them, you try to work out a plea. I remember one time, in talking about going to an expert, I had a case, and it wasn't even a big case. It was a aggravated harassment, criminal contempt, where the DA had phone records that my client called this other guy and threatened him. They had an audio which was kind of grainy. It's like the old mob ones, where you hear it and you're like, am I here? Is that so-and-so? And I'm like, I said to my guy, I said, they got phone records. He says, I didn't make the call. I said, okay, I'm going to subpoena your records because these are the records of the complaining witness. No call was made. So here you have records showing a call's made, not. I call an expert on spoofing. You've heard of spoofing. And he gives me he gives me an education. This was years ago, so I didn't even know what spoofing was. And I went to trial, and we won. Because the jury, and I kind of knew, if the jury says, wait a minute, the DA has one set of phone records, the defense attorney has another set, both subpoenaed records, that's reasonable doubt. And I got a not guilty verdict. But you have to sometimes listen to what your client has to say. Don't always take everything at face value, but he said, I didn't do it. If I was the kind of attorney that said, come on, they got the phone records, let's take a plea, let's get the heck out of here. And I didn't twist his arm because I said, I can work you out a good deal. He said, this guy got me in trouble before. You know, you have those kinds of cases where, I've had cases where I turned down an ACOD to go to trial because the client's like, my wife keeps getting me arrested or my ex-wife keeps getting me arrested. I got to take a stand.
I think one of the problems that our criminal justice system is facing is that when you actually represent an innocent client who tells you, I worked on a case years ago where the client said, there was no way I could have committed the crime, I wasn't even in the country. He was convicted of it, though. So post-conviction, you know, if he didn't have money, he wouldn't have been able to hire lawyers, investigators to actually track down the records from overseas to clearly establish he wasn't even in the country at the time the complaining witness and the DA charged that he was in the country and committed a crime, which he was guilty.
That's like the best alibi you can have. I wasn't in the country.
But nobody, not the prosecutor, not the police, nobody, not even the original defense lawyer, listened to the client and actually tried to track those records down. And I think over the years, Jabbar Collins is one of the perfect examples in New York, where Jabbar Collins, from a jail cell, used Freedom of Information law records requests, was able to obtain exculpatory information that had been withheld from him, and his conviction was eventually reversed because there was information in the prosecutor's files that had never been turned over to him.
That's amazing.
And one of them was witnesses were essentially being kidnapped, put into hotel rooms, and told that they had to stay there till they testified, and then they were going to be paid. In the Georgetown class, our students uncovered with another investigator that some of the jailhouse informants were paid, even though they never admitted that at trial, that they were able to track down through FOIL requests.
Brady information.
Actual receipt records that these witnesses were paid, and it actually had the money, the name, what it was for.
I want to ask you your opinion on something, and I represent Frank Vetro. There's a case that's still pending, criminal and also civil. And he said something to me, and when I had Jeffrey Deskovic on 2 weeks ago, he said the same thing. He said, it's almost like they have more rights and the ability to get more information in civil suits or freedom of information than they did at the trial phase. Like Frank brought a lawsuit. He found out things that he didn't know when he took his plea, that Jeffrey didn't know when he was convicted. Why? I guess the DA has control of that information.
So I'll give you, there's two answers to that. Number one, when you ask people what is the biggest and most powerful law firm in any county.
I say that all the time, the DA's office.
The DA's office or the U.S. Attorney.
I said that 2 weeks ago.
Why? They control everything.
Right. They have the resources.
Have subpoena power, wiretap power, everything along those lines. Number two, in my case, we had that exact issue where we deposed the medical examiner. The medical examiner said, I told Suffolk County Police at the time I did the autopsy that the alleged murder weapon in my case could not have been the murder weapon. First time we ever learned of that in the civil rights case. We ended up having to do a supplemental application because it was a Brady violation.
Well, you understand why that wasn't turned over. There would be no case.
Of course.
But that's, you got to do that.
But if you see that in wrongful conviction cases and you speak to lawyers who've worked on these cases, I would have to say 75% of them, maybe more, that information that had never been disclosed finally comes out through the civil proceedings. Right. And it's either through a federal court order that all records must be shared.
Right. Or it's just somebody saying, okay, let's just turn this over, here you go.
So that happened in my case. A few years after I was incarcerated, a family member filed a FOIL request to the Suffolk County Police Department. It was actually my Aunt Mary Ann, my mother's sister. She said, there are records that I want to see. The police department said there's an ongoing investigation. She goes, what investigation? You've convicted my nephew, who's in prison. She ended up getting records we never saw, ever saw. One of them included a confidential report that mentioned Todd Sturman. Another one was a confidential report.
So he was on their radar from day one?
Back then. Yeah. Another one said who the homicide detective should have been for that morning, which wasn't McCready. There was information that talked about radio communications because on that day, the first time in Suffolk County history, and never since then, did radio communications between the officers and headquarters disappear for a critical period of time when we were trying to establish my custody. So the original recording, every backup disappeared. Never happened before,
Wow.
but all of a sudden when we got the confidential records, the time of the malfunctioning of the system was completely different.
Gottlieb could have done a lot with that information.
Gottlieb would have done so much more, but he was up against an army. We learned after I was released that Detective McCready, who was the lead detective, was bringing witnesses into the evidence locker room before they testified, showing them bloody crime scene pictures and saying, listen, we have all this evidence against Marty, you know you got to testify the right way. We got evidence that McCready had convinced 3 young girls that I had met just a few weeks before September 7th to testify a certain way. 2 of them were sisters, 1 wasn't.
Wow.
After I got out, they approached the one, and the one said, we all lied.
You know, it's something. Half of what you just told me, a rookie defense attorney could have gotten acquittal.
Yes.
No question in my mind.
I mean, if you think about having the medical examiner say, in my case, very simply, okay, Jerry Stewman, son was a drug dealer who had enforcers to commit violent acts. Jerry Stewman fled the state. Jerry Stewman changed his appearance, had 5 different aliases.
Owed a lot of money to you.
Owed a lot of money. The confession was false because everything in it was only things that the police saw that morning. None of it proved up to any of the forensics. None of the forensics proved anything. McCready got witnesses to lie. I mean, all of a sudden when you start building all the evidence that we started to build after I was convicted through FOIL requests or civil rights cases,
Right. Wow.
it's just, even at the time we followed the 440, we had criminal defense lawyers saying, appoint a special prosecutor, because there was a huge conflict because Tom Spota, who was the DA back then, had represented Todd Stewman in private practice.
That's right. You know what? I think maybe you hit the nail on the head. Maybe we should submit a FOIL request to the DA when there's a case. I'm being a little facetious now, but it's those kinds of things. Bring out things that you didn't know about, or your attorney doesn't know about at the trial phase.
What I advise people, and I've done this for years now, is that when you're represented by counsel, have your lawyer do their normal discovery, have them do FOIL, and then have somebody outside of your inner circle, a family member, a friend,
Good idea.
do a parallel FOIL, because you don't know what's going to show up. And I think also what ends up happening too is that there's a change of guard in the DA's office. When all of a sudden an employee leaves, they may not be part of the good old boys network. They may say, you know what, this is, the defendant should be entitled to this. You get the records.
You got the record, yeah. Got to kind of wrap things up. Listen, this was fascinating. I'm going to bring you on my radio show to continue. If you have any specific cases you're working on, I know I told Jeffrey the same thing. I like to find out how you guys dissect a case, because it's easy. Someone could come in and say, I'm innocent. Maybe they're not. But how you go through that. So that'll be a topic for another show. That'll be great.
I actually would love that, because in this last semester, we actually just became co-counsel to one of our cases with a case in Ohio.
So I'd love to talk about that. So I just want to thank Marty for coming in. Like I said, this is his 3rd time on my show. It's always very, very interesting. It's fascinating because you get to see how someone who went through the system and came out the other side. And now he's an attorney. In fact, you work for Metcalf and Metcalf?
I work for Metcalf and Metcalf.
I have a case with them right now.
Do you?
Yes.
I'm an adjunct professor at Georgetown undergrad, and I'm also an adjunct professor at Touro Law School.
Yes, that's great. So again, watch my radio show, which is on every Monday at 5 o'clock, 103.9 FM, LA News Radio. This show is on every Saturday at 10 a.m., channel 115. I wrote a book. We don't have a lot of time. I wrote a book called Divorce: A Practical Guide, a great read. You can go to my website, JusinoLaw.com, or you can call me, 631-588-3155. You have a great day. Thank you, Marty.
Thank you.
Take care.